All right, David, it's good to have a defense attorney's perspective on here to talk about Lori Vallow. And I want to ask you right off the bat, if you were her advisory counsel and she would listen to you, what advice would you give her at this point? One, as far as her sickness, and two, if jury selection does proceed.
Well, if jury selection is going to proceed per the judge's order, then it's certainly best not to compromise or complicate your case from the outset. And I would advise my client, Miss Lori, were she to continue to be legitimately ill, that it would probably be best if she gave we lawyers a list of the kinds of jurors that she would prefer, and that we went ahead and started the process on the day the judge dictates, in her absence, with her perhaps monitoring at long distance from the jail and giving us a right to confer once or twice confidentially by jail communication before we make our final selections. It certainly would not be a good thing to entirely alienate the entire panel too many days in a row by bringing them back to the courthouse for no particularly good reason.
Interesting. So you're saying she could monitor and watch remotely from the jail as they do this jury selection, and then her attorneys are already armed with the type of questions she wants to ask.
Of course, I'm assuming that the connections would be available to do that.
Right.
But for the most part, those kinds of jail courthouse connections are readily available in every modern courthouse in the United States.
Right.
And the ability to communicate on final jury selection, which comprises just a very few minutes at the very end of an often very long interrogation process, is something that could be communicated in terms of counsel and client remotely, given her notes and the counsel's inclinations in a confidential setting. But given the fact that her prior jury selection was comprised pretty much of a 10-minute speech, the kind of thing that I'm suggesting, using the professionals in the way that we typically conduct voir dire selection, drawing out more about the personality and the history, the inclination of the jurors, rather than just giving two or three broad questions or a little 10-minute speech, would probably be more effective in selecting a potentially objective jury than anything Lori could do herself, healthy or sick.
She seems to kind of enjoy the spotlight, or at least not mind it in the previous hearings. She says she doesn't like
But
camera.
you're the guy that thrust her in the spotlight. I don't know
Well,
why you think sticking a camera in her face in Hawaii would incline her toward that
I
situation.
don't know if she enjoyed that moment, I will say, but the rest of the moments, how much is theater in these type of trials? High profile court TV's there, everybody's talking about it. She shows up in a wheelchair yesterday and it makes headlines. I mean, how much do you, and as a defense attorney, do you want a little bit of theater to kind of tell your story and move the case along?
Well, I presume, and let's presume for purposes of this discussion,
Right.
that she really does have a malady. Something about what she did say rang true to me in that regard, and that was namely that she'd made complaints and requests to the jail authorities, and they had not promptly responded back to her with regard to objectifying her illness. Nobody took her temperature. Nobody reported that she had the symptoms of XYZ. She was not supporting that in the courtroom. And where she's had this history for a couple of 3 days, there should be some kind of jail analysis from the medical personnel there that either substantiates and confirms or undercuts what she's telling the court. So, assuming, as I do, that she is ill, and assuming that the jail is just operating on standard procedure, they're not a drop-in pharmacy, they're not a drop-in medical clinic where everybody's seen in 10 minutes and an instantaneous analysis is had. I'm presuming, therefore, that her utilization of a wheelchair yesterday was probably an alleged confirmation of her personal felt weakness or inability to conduct herself in an appropriate gait without uh, being weak or dizzy or something else symptoms that she reported. So I'm not necessarily assuming that her use of a wheelchair was an aggrandizement for TV, but I do think that she may be, of course, as some defendants do, and occasionally some lawyers do, uh, reporting that the symptoms are more aggravated at a time when it might be uncomfortable or inconvenient to start a difficult process. But she does need to report for work. After all, it's her trial, her counsel, and her situation. It will go forward, and I would expect the judge will probably start jury selection with or without Lori here on the next scheduled occasion.
Mm. Yeah, I do wonder if you have to, as a judge, be careful when she's representing herself as far as giving her enough chances if she really is sick, but then it gets to a point, kind of like parenting, right? With your kid. If they say they're too sick for school, but they can go to a concert that night, you gotta lay it out. So let's hope that the jury selection happens tomorrow. Opening statements get underway tomorrow or the next day. This is a conspiracy to commit murder case, and the alleged victim is alive. What does the prosecution have to prove, Dave, to make this jury find a conviction? And what does the defense need to do to try to persuade them that Lori was not the culprit?
Well, attempted anything means the job didn't get done, and in attempted murder, it's always easier to prove if there's an injury or if there's some kind of impactful situation, which, but for the course of medical heroics, would have accomplished the homicide. So, in terms of an attempted homicide here, where the victim is not reported to be deceased and is available to testify, whatever acts are alleged collectively against that individual have to clearly signal that there was an intent to kill that person and that there was a premeditation, a deliberate attempt to kill that person. It didn't occur in the course of a fight. It wasn't the result of negligence. It was intended to be a homicide, and but for something else, it was not accomplished. The conspiracy element then means that there are two or more people who acted in combination to attempt to accomplish that activity. And that is often proved by communications of one type or another, the proximity of people at a critical time, the payment of a emolument or a money for some kind of activity. All of that together can constitute a conspiracy to accomplish a particular purpose. If I'm the prosecutor, I've got a complicated case on my hands to try to show all of those elements. The extent to which Lori may be personally, centrally involved in that, I'm unaware of in the instant case, but presumably by virtue of emails or telephonic communications, proximity at critical times, the prosecutor will be able to show and allege and argue that Lori was the central figure in all of this, and the conspiracy evolved around and away from her. If I'm the defense lawyer, I would say we don't have a homicide here. This is not a situation where anybody attempted to commit homicide. All of this is speculation. There may have been some bad blood. There may have been some good blood. We've got relatives involved. This is much ado about nothing, and nothing happened here, would be my argument as a defense. Prosecution will still tell the story, focusing on this particular set of allegations only, that this woman was so depraved and had such a nasty inclination that she was able to do this desperate deed, acting through a third party whom she instituted to do that. And the defense is going to tell the story of no touch, no foul. There's no crime here.
Yeah. Well, we'll see what happens. This is the one case out of all of them that is different because the victim is alive. The rest of the cases, we didn't have the victims alive, and they had pretty strong evidence. And we'll see. David, anything you want to add?
No, Nate, it's always a pleasure to be with you, and I'm glad you're representing Idaho, East Idaho, the entire nation on duty as always in a Lori Vallow case.
Well, thank you. I'll represent the whole state, not just East Idaho. I'll take it all. Thank you.